Okay, good afternoon.
Good afternoon.
We'll go ahead and start this order to show cause hearing. This is in case 21-920. And we go ahead and state your name, sir?
Eduardo Mejias.
All right, Mr. Mejias, let me just go ahead and go over why you're here. You filed a petition in this case on April 15th of this year. This court ordered when Judge Rexeder responded to your petition on April 23rd, we ordered 3 days later that you file a reply within 10 days. You did not file a reply within that time period. On May 19th, we also issued an order to show cause why the petition should not be dismissed due to your failure to respond to the court's order. You also did not fail to respond to that order. So as a result, on June 2nd, we dismissed this case or your petition and scheduled this order to show cause hearing. Now, we did receive your response of June 6th, where you apologize for failing to comply with this court's orders. But I want to go ahead and start this hearing and ask you, to give an explanation as to why you failed to comply with not one but two orders from the court.
Well, Your Honor, when I first got the petition to writ of mandamus filed, my intention, of course, was to get a long overdue hearing scheduled from my client who had been waiting a year to have a return hearing on a pickup order. I filed a petition for writ of mandamus with the goal of having a hearing scheduled by the trial court. I saw the reply filed by Judge Rexeder shortly after, and then shortly after that and before my reply brief was due, I did, or my office got in touch with Judge Rexeder's office. I should say they got in touch with us and the opposing attorney and coordinated a hearing date for the return hearing, which would be June 8th, which already happened as a matter of fact. So once the hearing was scheduled, the goal of the petition for writ of mandamus was satisfied. And I do admit that I should have responded with some kind of, well, my reply at that point should have been that I should have actually just withdrawn the petition in hindsight because I'd already have the hearing scheduled. But because my first priority was to satisfy my client's need for a hearing, I didn't, and that was my mistake. Once I realized that this court wanted an explanation, I filed my reply on June 6th, trying to explain the best I can why the actions I took, or the inactions I took, I should say, how they happened. We had the hearing on June 8th, so that was already done. All I can say is that I didn't follow through like I should with the court. My client was satisfied, but I realized I have a duty to this court to keep it abreast of what's going on in the trial court.
Well, you said you filed a reply on June 6th, but between our April 26th order and your June 6th response, we filed another order which you didn't respond to. So, in your explanation, you kind of skipped that order as well. So that's, so why'd you skip the second order?
Because at that point, dismissing the petition for the mandamus would not have harmed my client because I already have the hearing scheduled. I'm a results-oriented lawyer, so when I focus like a laser beam on the results, getting from my clients, getting the right result from my client, I move on to the next matter. That's how I operate.
What if the trial court the day before the hearing had canceled it for some reason and just said, I'm not available until October? How would that have advantaged your client when you'd have now allowed his petition to be dismissed because you didn't respond to either order?
Well, I understand that question, but every indication was that the hearing was going to be June 8th. The other side had agreed. And in my time to file the reply, I don't know what I would have said other than the hearing had already been scheduled. I couldn't anticipate something that hadn't happened yet, which would have been canceling the hearing. So I'm not sure how I would have responded in a reply.
Just so we're clear, it sounds like what you're saying is that you received both orders, correct?
I'm not denying that I received both orders. No.
Okay. My challenge, Mr. Mejias, is that I was on another panel in case number 20-235, in which, well, I'll ask you to tell me how the behavior is any different in that particular case than in this one.
Well, in that case, the word order to show causes that I did not reply to. There were multiple ones, and I admitted that I just didn't see them. My explanation for that case was simply that I had already been taken off the case by the trial court, and I wasn't looking for any orders from the appellate court, this court, regarding that appellate case, which my client had done pro se. So that was a case of oversight, perhaps, if you want to call it that way. As far as this case is concerned, I did receive the orders. And again, there was an error in judgment not to file some kind of reply to state that the hearing had been scheduled. But it's not like I didn't see the order and just forgot about it. I wasn't sure how exactly to file a reply to something that when the goal had already been satisfied.
So we can get to that in a second, because I think it's probably 3 sentences long. But in any event, I look at the dates and the sequencing from that last case in comparison to this one, and it gives me some meaningful concern. So on January 20th of this year, we sanctioned you for not responding to multiple court orders directing you to respond. There was a $200 fine, and we sent you to the Ninth Circuit Professionalism Committee. On March 8th of this year, they issued their final report. You were shown as copied on it. Did you receive it?
Yes.
So it says, hey, we had a productive discussion with Mr. Mejias. We appreciate his candor. And it was pretty clear to me that they decided that your behavior in case number 20-235 was inadvertent. Is that a fair characterization of their report?
Yes.
So on April 26th of 2021, as Chief Judge Evander just said, which by my count is 1 month and 2 weeks, about 45 days away from that Professionalism Committee report, seems to me that you do the exact same thing again. I have 2 questions for you. One, how, based on that timeline, can we perceive your behavior in this particular case to be inadvertent? And then secondly, what would you do if you were us?
I don't believe that this case can be characterized, my behavior can be characterized as inadvertent. I just believe it was an error in judgment and not.
Would you characterize it then as purposeful? Because that's
No.
kind of what I'm worried about, because I felt like the last panel gave you tremendous benefit of the doubt. You know, we were asking about your staffing situation. We were asking about your practice during pandemic. We were asking you about how your orders got docketed when they came in. You explained some challenges that you had with staffing. You, like a lot of people, are splitting time between 2 different offices, or at least you were at that particular point. And I specifically expressed my concern that when you're not responding to our orders, I worry that you're missing other orders. And I worry that missing these orders might disadvantage your clients. And if, for example, you've got a pending petition for mandamus where this gentleman allegedly hadn't seen his kid in a year, what possible good does it do to get his petition dismissed?
I respectfully disagree that my client was prejudiced in any way. If I thought for a second that dismissing the petition after the hearing had been scheduled, and I was fairly confident that would have been scheduled, of course I would have responded. In the other case too, my client was not prejudiced per se. In fact, she wasn't even my client anymore. I reiterate that I do understand that it seems like there's a pattern of behavior here. It's certainly not intentional. all I can say is I'll make a promise to respond to all orders by this court, whether or not the underlying matter has been resolved or not. The
What
difference
would you do? What would you do if you were us? We sanctioned you last time, and then 6 weeks later, you do the same thing. So is a sanction, in your estimation, appropriate? And if so, what should we do?
well, it's hard to be objective here, but I mean, if this court believes that another monetary sanction is appropriate, I'm willing to pay it. I'm also willing to take any other classes that may be appropriate for appellate practice. I don't honestly don't know what else is available as far as sanctions are concerned.
Well, I guess we could send you back to the professionalism committee. We could refer you to the bar. I don't know necessarily what class we could have you take that would teach you how to respond to a direct order from a court saying to file a response. But
Let me follow up here. You know, in a big picture, you do family law. I mean, I'm sure there's been numerous occasions where an opposing party has failed to comply with a court order and you have filed a motion to enforce or motion for contempt. Would that be correct?
Certainly, yeah.
Okay. And, you know, as an attorney, we obviously expect more of you than we expect of clients. We expect our orders to be complied with. And it's not just a matter of a judicial order and an attorney. You know, as a trial judge, when I got an order from the 5th DCA telling me to do something, I moved quick on it and felt obligated to do it. As appellate court, when we get an order from the Florida Supreme Court telling us to do something within a certain time, we make sure it's done. I mean, that's how our whole system, our whole judicial system works. And we expect, you know, in the case of judges, to comply with directives from higher courts. In the case of attorneys, we certainly expect them to comply with court orders. So that's why I also have some real concern about you saying, well, I didn't think it was necessary, it's poor judgment. It really shouldn't be a judgment call. You have a court order. You comply with it or you appeal it. Those are your two choices. You know, saying exercising your judgment, I don't even know where that comes into play. So, and like Judge Traver said, it would have taken a 3-sentence reply to say the hearing's been set. And that would have done it. We wouldn't be here today. So it's kind of baffling to me because I don't know if we've ever met, but what I understand about you is you're a capable attorney. So this, in a lot of ways, it baffles me. So part of this hearing is to try to find out why a capable attorney can't do something as simple as complying with an order with a 3-sentence response.
In retrospect, I should have done that, obviously.
Are there any other questions or comments from the panel? Okay. Sir, would you like to make any closing remarks?
I understand that this court was unnecessarily burdened by lack of response in this case, and I'm sure the last thing this court wanted to do was to have yet another hearing with me. I am sincerely remorseful about not filing a response in this case. I don't claim that I didn't see the order because that would be a lie. I did see the order. I was so focused on obtaining a result from my client that I lost focus on what else is important as well. I apologize for that. All I can say is I promise it won't happen again. And if this court, I ask this court for some mercy. I do expect some sanctions, but I do want to continue practicing in appellate law as well as in front of this court.
All right, well, we will, adjourn to consider sanctions. One of the sanctions, one of the options on the table, and I'm not saying whether we'll exercise it or not, is certainly notification of Florida Bar. Certainly, if this happened again, it'd be hard not to do that. As on this case, we'll have to discuss that. All right, thank you, sir, and we'll be in recess.
Thank you, Your Honor.